Hey, Mark and Tina, can you give us an example of how you helped clients after litigation to resolve leaky building issues?
Okay, so look, I'm just going to answer the question anyway, Leo. So we've been involved in multiple construction projects. On one of the ones recently that we gave some high-level advice, the building cost was about $205 million. The parties were fighting over about $500,000 at the end of that project. And in the great scheme of things, I call that a win. Sometimes I'm the beauty, Tina is the brains, and we will play to each other's respective strengths in any litigation or commercial dispute about the terms of the contract. Tina and I have also been involved in a number of the biggest leaky building claims where the parties have come to us to put the construction contract around the repair work to try and avoid a second generation claim. And Tina's skills in drafting those contracts has been very beneficial for the apartment owners who have been through a long and painful process.
So we've actually headed litigation claims against contractors and various parties for owners. That has often taken years in the High Court, but we've also been involved in cases where the litigation lawyers have come to an agreement with the parties in a long leaky building claim, and that settlement was conditional on entering into a construction contract within 24 hours. So all the parties came into our boardroom, we were putting things up on our screen and just getting through and trying to negotiate a full construction contract ASAP. It took a few days, but all the parties were on par and we managed to get the contract signed.
And I guess one of the other answers to that question, Leo, why we were voted the top property construction law firm in New Zealand for 5 years in a row, because a lot of the parties like working with us, because on most projects you're going to have a few little disputes. Tina and I have been in a lot of tool sheds for the morning smoker with the hard hats on, and we've seen issues arising on projects, and we've sometimes managed to help the project managers just put the fire out early on in the piece instead of it becoming big, protracted and expensive litigation. We're very skilled at that sort of agile response.
Yeah, because unlike other lawyers, I think I've been to court, I've also been on projects, I've also been on different sites or meeting rooms with clients as well as our boardroom.
Yeah, and Tina therefore has a depth of knowledge unlike most construction lawyers, where she can deal with the contentious and non-contentious work, which gives us some real special skills in the sector.
Can you give us examples of how you help to resolve contentious matters and keep it out of court?
Yeah, so we've had many negotiations within our boardroom. So we've actually had parties come into our boardroom to resolve matters. Often in our construction contracts, we put in dispute resolution clauses that said, first and foremost, if you have any issues, you must raise it, and Queen City Law will get in there to try to resolve. And it's not because we're trying to take fees or escalate matters. What we're actually trying to do is de-escalate matters and keep it out of court. And that's been quite successful because we've had parties in our boardroom all come together, and we said, what's your problem? What's your problem? You know, how can we fix this? How can we keep the money in the project instead of paying lawyers and going to court?
Well said, Tina. And some of those ways of getting the parties to settle take experienced mediators and skills at bringing the consensus ad idem to get a meeting of the minds. Even if nobody's happy, we get a result that everybody can live with and get on with the project.
And those meetings are not easy because people swear,
Yep.
people try to get violent, and we've seen everything, but we've luckily been able to resolve a lot of that as well.
Yeah, often ending up in the parties shaking hands, and there might be the odd tear and they get on with it.
And sometimes a beer afterwards.
Yep. And I must say, I think we're highly skilled in that contentious space. Sometimes litigation will be unavoidable, or there'll be an adjudication or an arbitration under the Construction Contracts Act because there's just no way they're going to meet. But often we've been able to pull projects back together and get them back on course.
But if you need legal advice, come and see us as your construction experts, also able to assist in any disputes.
Thank you.